Well, when you post to your Facebook or Twitter accounts, you probably aren't thinking about being involved in a lawsuit. But a recent decision of the Michigan Court of Appeals reminds us that social media indeed can be used in legal cases. Here to give us some of the basics, attorney Tom Sinus of the Sinus Dramus Law Firm, talking about this interesting topic. And Tom, first and foremost, talk about the most common misconceptions we may see, at least in your practice, about social media and the legal system overall.
Yeah, that's a great question, Derek. I think if I had to state it generally, I think the misconception people have is kind of what your intro alluded to. The idea that your social media life would somehow be separate from your life if you were involved in a lawsuit. And I think people think this maybe for good reason intuitively. Maybe they increase their privacy settings on their social media account so that people can't access it. But it's in terms of the law itself, if that it doesn't matter how strict your privacy settings are. Things that you say and do online, not all the time, but in certain instances, can be used in a lawsuit if you're a party to a lawsuit, or even if you're a witness to a lawsuit. So I think what people forget, maybe in general, about social media is that it doesn't necessarily exist in a vacuum, and that's true for the legal system as well.
Yeah, good reminder. There's a lot of not responsible things out there on social media these days. Let's talk about people's social media being used in a court case as well, Tom.
Right. Okay. So how can it be used? Well, there's two concepts generally that apply. The one is the question, is your social media material what's called discoverable? Meaning if you're involved in a lawsuit, can the other side try to get access to your social media? And the answer is yes, sometimes, maybe not for everything, but it's not uncommon in my practice to see one side looking at the social media accounts of the other. It's also not entirely uncommon to have one side request that the other side produce their social media accounts. What about in court? Well, we call this admissibility. Is social media admissible? And again, sometimes yes and sometimes no. But the most common situation is a rule of evidence that's called a statement of a party opponent. And this just means that, Derek, if you and I were involved in a lawsuit, statements that you make are admissible in the case, my case against you. So if you make a statement on Twitter or you make a statement on Facebook, I can have that statement used in the actual trial proceeding. And what we see over the course, particularly the last 10 or 20 years, is we see more and more social media, of course, and that means more and more social media data and information being used in actual trials.
Interesting to think about. A good reminder for all of us out there. Tom, where do people track you down? They want more information from you.
Well, they can find us online at www.sinusdramus.com. They can shoot us an email at info@sinusdramus.com or give us a call, 616-301-3333.